Hello, everyone. Welcome back. Um, our session is Claim on You, proactive steps you can take to avoid IP malpractice claims. This session is sponsored by Clio. Thank you, Clio. I am Bree Van Til. I am the Director of Education at Alt Legal. I'm your Master of Ceremonies. I'm just here to make sure you have a good time. So if there's anything you need to make you have a good time, let me know. All right. Of course, this is a Connect session, and so I need to remind you, don't be a jerk. I don't want to have to ask you to leave, but I know you won't be a jerk because you are all lovely and wonderful people. All right. So this session is for CLE credits through the state of California. It's also for ethics credit specifically. So be here the whole time. So it is for live attendance only. I can't give you CLA credit if you don't watch this live. I need you here for the entire 70, that is 70 minutes. And make sure to write down the code that I give you and put it into the survey. We try really hard to remember to put the survey links into the chat at the end of the session. But in case we forget, all of those are in the recap emails that I send out every evening. If you did not get a recap email last night, please let me know. Start by checking your spam folder. And if it's not there, please let me know because you will see those links in there. You'll also see links to all of the materials in case you need those for your CLE credit. All right. So you will put the code into the survey that I send you this evening, or that you get from the chat. All right. Alt Legal, still a tech company. We're not a law firm. We're not giving you legal advice. And these views are Tracy's views. I'm sure they're great views. They're not necessarily Alt Legal's views. Um, if you have any questions for Tracy, make sure to put those in the chat. But it's really helpful for us if you start that chat with question so that we know to get those over to her. Either way, we'll probably get them there, but it's a lot easier for us if you do it that way. All right. I'm really pleased to welcome Tracy Kepler. Tracy is the Risk Control Consulting Director in charge of global specialty and lawyers professional liability.
That's a
That's,
lot.
it's a lot. That's a really long title. That's how we know how important you are,
See,
Tracy.
no, I like to say that title says nothing. What I am is I am about keeping lawyers out of trouble.
Yes. All right. She's served as an ethicist for years, including at the ABA. She's taught legal ethics and professional responsibility at Georgetown and Loyola, American University. She knows her stuff. Listen to her. Don't get in trouble. Here you go. Here's Tracy.
Thanks so much, Bree. I really appreciate it. Let me see if I can get my slides up here. Up, and there they are. I need to go back to the beginning. Give me a second. As Bree said, we are here to talk about proactive steps that all of you can take to avoid the claims that we're going to be talking about today during this program. I've provided my contact information. If you have questions that we can't get to during the course of this time together, or you have other questions, and you just want to reach out, please do. My email is there. My direct dial is there. My cell phone is even there. So please feel free to contact me. I'm happy to speak to anyone at any time. Like alt legal, what would I be? What kind of attorney would I be if I didn't start with my own disclaimer? Basically, what you're seeing in front of you is saying that there's no attorney-client privilege created by what I'm saying today. And really, this is for guidance purposes only, not legal advice. So with that, I will get started. And sort of the mission of the next hour and 10 minutes or so that we're together is really this statement. Not a statement I can take credit for. I will credit the U.S. Marine Corps for this statement. But think of it this way. It's very alliterative. Prior planning prevents poor performance. We're thinking about being proactive. We're thinking about taking steps before there's a problem, doing things that we can put into our own practice, our own IP practice, whether it be solo, boutique, large firm, steps that actually take a step back, that make us think, that make us realize what we're doing so that we don't end up either in regulatory or disciplinary trouble before the OED at the PTO or before legal malpractice trouble. So, what kinds of things are we, and I'm talking we in the insurance industry, seeing in legal malpractice claims in the IP sphere? Honestly, generally speaking, conflicts of interest are the number one cause of legal malpractice complaints. However, when you part and parcel it out and you look at trademarks, you look at patent, you look at copyrights, what we see the most are really missed deadlines. Not only filing deadlines, but payment deadlines. And one place that I'll turn you, if because we all have so much time for other research, one great area where you can find sort of anonymized data on all the claims that come from carriers is the ABA Standing Committee on Lawyers' Professional Liability. Every 4 years, they produce a claims data survey, and it takes data from all the insurers around the country, anonymizes it, and tells you about trends, tells you about where we see errors, and the practice settings. It really is quite a great resource to check out. But as I was saying, in the IP sphere, missed deadlines are really a biggie. In addition, what we're looking for and what we see are due diligence errors. When I'm talking about 11103 here and 11104, communication, doing things diligently and promptly, not looking into prior art research, poor advice, not doing enough research, and giving bad advice, particularly on infringement, drafting errors, looking at 11101 competence, not just as it is in the PTO rules, scientific and technological knowledge, but the legal skill, knowledge, thoroughness, preparation that's required to complete those applications. This one's a biggie, and I think this one is across the board, not just with IP. It is when an attorney, a practitioner, files suit, a collection action to collect unpaid fees, and immediately comes the counterclaim of legal malpractice. It's a counterclaim to a suit for unpaid fees. Improper release of funds from escrow, a frequent something that we see. Dabbling, big one. Practicing outside of your practice area or your jurisdiction, and quite frankly, the reverse. I mean, when we see IP people handling incorporation or commercial transactions because the scope has expanded, or the reverse, trademark practitioners or people who don't routinely practice in the trademark sphere coming in and representing clients before the PTO, not knowing exactly what they're doing, not knowing everything that they need to know, and quite frankly, not recognizing that they are opening themselves up to the jurisdiction of the OED for disciplinary purposes. We also see a lot of litigation-related claims, missing statutes of limitations, failure to designate and file, proper experts timely, the sort of settle and sue things that are very common. And one really burgeoning area that has brought in not only large claims, but more recent claims is the exceptional case finding. It really is one of the emerging trends. It's been around forever, right? But in 2014, the standards were really clarified. And so there are more filings. And I was speaking to a person in our claims department, and actually just today, there was a a claim where it was a position, it was a merit list filing as well as a lack of due diligence. So another emerging area. So let's start. And what we're going to do is go through some claims that have been anonymized, look at the issues presented, look at the resolution, how it was actually resolved, and then actually look at some of the lessons that we can learn to be more proactive, that prior planning, so that maybe we could have avoided this issue, or I should say the insured could have avoided this issue altogether. So the first one, it's a missed deadline one. And in this one, the law firm is retained to manage portfolios across the board, right? The company's worldwide patent portfolio. And as happens, and as often happens, the firm uses another law firm in another country as its foreign agent. The other country's PTO deadlines, to issue the patent, and they miss it, right? And then a firm is instructed to appeal, and then they give the correct deadline, right? Oh, rats. The ABC firm doesn't timely file the appeal. They miss it. And so there's no patent. They lose on this. And the company claims that this completely impairs their ability to license the intellectual property. So what happened in this case? Well, luckily, the claim was reported promptly. A lawsuit wasn't filed. A malpractice lawsuit wasn't filed. Defense counsel was retained early on in the negotiations. Because defense counsel came in early on, they were able to hold an early mediation that included an informal exchange of documents. The focus of the discussion was really on the causation and damages issues. Was it patentable in the first place? And also an analysis of the specific marketing for the licensing of this IP. Luckily, after a successful mediation, direct negotiations, more document exchange, that actually resulted in a near year-end settlement. And why do I say near year-end settlements? Because the timing was important, right? It was close to the end of the year. Billing, cycles, financial cycles, end of year cycles were coming to a close. They wanted it to be resolved. They wanted it off the books for that year. And so it came to a successful resolution. What do we talk about this? And why do we talk about it from a lessons learned standpoint? As I said, a huge area of claims coming in. How can we avoid missed deadlines? Being proactive. I mean, the bottom line is having an effective, reliable calendaring and docketing system in your practice, whether it be small, boutique, medium-sized, large size. It has to be reliable. It has to be maintained. The information is only as good as that which is put in or that which is gathered from the PTO directly. And it has to be maintained. It has to be updated. In addition, in this age of cybersecurity, in this age of hacking, in this age of ransomware, making sure that backup calendars are kept with the critical dates, that they're held separately and apart from a main server, and that they are verified weekly. Sometimes I think that could be a little bit more quickly than weekly, but weekly for sure. Also, ensuring central quality controls. Having a team of individuals that is responsible and sort of beholden to these tasks. They have the whole team has read access, but there's only going to be controlled access to edit, enter, or delete data. Can't have the whole team going in there and changing things around. Just a select few. You also want to have second eye checking. And this is particularly important because we've seen a lot of cases that go awry or cases where deadlines are missed over the holidays. right? Somebody was supposed to be checking, but that person was on vacation. The backup, took leave unexpectedly. And then there was no one there to make sure that these deadlines were checked and that were made and were alerted. Um, Obviously, in the underwriting process, that is one thing, the calendaring and docketing systems that firms have that underwriters look at. What do you have in place? What does your team look like? How are you monitoring this? How are you backing this up? It really does go to the risk presented. With larger firms, clearly they have their own separate department that handles this. But clearly there needs to be some specialized training for that department as well as others in the team so that they can support and depend on the data. Having a designated email account or an inbox for inbound documents, not going to, higgledy-piggledy everywhere willy-nilly. One receptacle, one place that can be checked for PTO mail and correspondence, for clients, for foreign agents, all have the mailbox, and it's monitored on a daily basis for what's coming in. We'll talk about zeroing it out as well. So I like to say procrastination is not your friend. If you hang on to these things and you say, I'm going to do it all on Friday afternoon, no. Calendar all upcoming deadlines as they come in upon receipt. This is how things fall through the cracks, and you really don't want this to happen. Having a policy of doing it when it comes in. Another thing to consider, we have the deadlines, we have the filing date, the payment date, but think about soft dockets. Think about, again, prior planning. Thinking about tickler dates ahead of these hard deadlines. Checklists at stages a few weeks out so you can prepare. So everything doesn't have to be an emergency when it shows up. Oh, this is due tomorrow. You also want to align this system with client guidelines. This goes hand in hand with the look ahead dockets. I talked about it maybe a couple weeks, maybe a month, but maybe even a 6-month plan of action, right? A long-term docket that gives you deadlines so you can plan your workload and the workload of others. Assigning multiple responsible parties in the matter records. Like I said, somebody goes on vacation, there needs to be a backup. Somebody goes out unexpectedly, there needs to be a backup. That can be the attorney who's working on the file, who's responsible for the legal services to the client. It could be a supervising attorney. It could be a partner or the client relationship owner, a paralegal, an agent, whatever the case. You need to have other people involved who can step in case somebody is gone, as well as having a plan in place, an escalation path, as I call it, when these statutory deadlines approach, what you're going to do, how you're going to get it done. Daily quality controls are also very important. I talked about the zero docket, having someone in your firm responsible to make sure that everything that has come in that day, everything that needs to be docketed for that day has done so, and it's zeroed out. That email box is empty by the end of the day. You also want to set some expectations. And here I'm talking more about firm culture. Making sure that everybody understands that compliance with the firm's docketing and calendaring guidelines and systems is mandatory. It's not a request. It's not an invitation. It's what we do. This is the policy by which we abide, and you need to do so as well. You may even want to consider compliance with that plan, compliance with the recording, linked to or part of performance evaluations. And then always, the policy is no good if actions don't have consequences. You need to build in escalations, and you need to build in consequences for failure to do or to abide by according to the plan. So let's move on to claim number 2. And then this one has to do with advice issues. In this case, the law firm was retained by a family to provide advice on whether its IP infringed on a competitor's product, and then to defend the family in the infringement litigation, which actually ended up settling for $550,000 after the summary judgment, the competitor's summary judgment motion was granted. The family alleged that the advice that their product did not infringe led to all kinds of unnecessary litigation and an adverse Markman interpretation. And the settlement, as well as getting, they had to get new counsel, successor counsel fees. The family also claimed there were all kinds of litigation errors through the process, improper discovery, failure to warn them for the potential for the adverse verdict, as well as recoverable damages. So what happened here? Suit was actually filed and defense counsel was retained, and this went through an extensive litigation. There were 2 days of mediation. The demand was never below 1.5 million. Ultimately, the motion for summary judgment was denied. 2 days of settlement conferences where the judge didn't produce a settlement, but in the end they agreed to a baseball arbitration. And for those of you who don't know, it means, usually the judge can, two sides give what they want and the judge comes to some happy medium. With the baseball arbitration, you have to pick one or the other. There is no middle ground. The family actually submitted the settlement for around $2 million. The other side, it was a mid six-figure number. Luckily for the insurer here, the mid six-figure number was chosen and the case ultimately resolved. What I like to talk about with regard to this case, and there were some other details that we don't have time in this forum to go through, is about vetting, about client vetting, about not taking every client that walks through the door, about doing some due diligence into that client before you sign that attorney retainer agreement. Some signs to look for, and I say bad in quotes, difficult, could be problematic, could result in, malpractice or disciplinary matters, but some red flags at the outset that you want to be wary of or at least mindful of. Certainly, when we talk about, collection actions, poor finances, do they have the ability to even pay for this litigation, for the representation? Clients who are very difficult at the outset. They won't meet you in person. They're difficult to get a hold of. You reach out to them numerous times. They never respond to your calls. Or when you first meet with them and you talk about the case, their expectations are unrealistic. What they're asking for, their objectives, are never going to be able to be met. If you're the sixth attorney, in the succession line of representation, have they fired or sued their prior counsel? I love this case when I talk about family members or close friends. The Wildy case is actually a case out of Illinois. And I bring it up. It's not an IP case, but I bring it up because I think all of us have had that family member, that friend, that colleague reach out to us to say, can you just do this for me? Or can you send this letter on your letterhead? Or can you come, represent me in this traffic case, whatever the case may be. And I think this is an area where it's very hard to say no, but you really do need to be leery and think about it before you take the case. Just briefly, the Wildy case, it was a case, like I said, from Illinois, where the underlying case led to a legal malpractice case. And Wildy was the plaintiff, and she decided to sue her former fiance for breach of promise after he broke their engagement. And Wildy asked her friend Paulson to represent her in the breach of promise lawsuit. And she agreed to pay Paulson $1,500, but Paulson said, I never got that money. She never paid me. Wildy prevailed at the trial, and got a judgment of over $100,000 against her former fiance, but then the verdict was overturned on appeal. And the appellate court reversed because the notice to the former fiance that Wildy wrote and sent failed to contain the date that the engagement commenced, which was a necessary requirement under the applicable statute. And so what ends up happening? Well, you guessed it, Wildy sues Paulson for legal malpractice. Paulson said, look, I was just doing this as a favor. I only filed the appearance to help out my friend. I was the Wildy was going to do all the work. It really wasn't up to me. But the court said no. The court said, ruled in favor of Wildy and said, you know what? Paulson's engagement letter didn't limit the scope to just a general appearance, and so kept her on the hook. And so I think it's a case of be careful, right? Those family members, those relatives who reach out to you, think about it before you get involved. The other thing to think about is the client who comes in at the 11th hour. I've got to have this filed by tomorrow. It's going to run. I'm not going to be able to get it. Where have they been? And taking it on at such a late date may be problematic and lead to future problems. And how about this one? Just going with your gut. There's something not right here. I'm getting an icky, odd feeling. I don't think I should take this client. Always a good call. Some other risks of not performing this due diligence on your potential clients, like we've seen, all kinds of legal malpractice, attorney or practitioner disciplinary actions, funding, financial, lost revenue. You could be disqualified. You might have to disgorge your fees, not to mention sort of the unquantifiable, the reputational damage to the law firm. The other risks to consider, and here's where the legal malpractice and your policy really comes in. Consider your coverage. Before you accept this client, consider the potential damages of a legal malpractice claim should something go wrong. Do you have enough coverage to take on this client representation? And the example that I give is it might be great to take on this multi-million-dollar commercial real estate representation or IP representation or infringement matter. But what happens if things don't go well? What kind of coverage do you have, and will it be exceeded? Building a book of business is important. Bringing in clients is important to the success of your firm. But not all prospective clients should become current clients. And you have to make a decision as to whether or not you're going to have them sign on the dotted line and you're going to take that case. Asking the right questions at the outset may make it clearer for you which clients are a good risk, which clients are a good fit, sort of the right client at the right time on the right matter for the right amount of money. All questions that you're going to want to ask at the outset. And also once a prospective client, after that initial intake, transitions to a current client, it's much harder to withdraw from the representation as to, where it would be easier just to decline taking them on in the first place. The other thing is, and we'll talk about this in greater detail later, keep track of what fees are owed to you and act very quickly to resolve those issues. Some other strategies to consider, really ethical strategy within the confines of the rules of professional conduct. I talked about objectives earlier. When we talk about 11102A, the scope of representation, the client comes in with what they want you to accomplish. Get me a patent, get me my trademark. You as the attorney, the practitioner, are in the best position to use your means to get them what they want. If those two things are not aligned at the outset, or there's not some reconciliation or discussion about it, it could be a problem, and it could lead to a problem under that rule. 11104 and all of its subsections are key. Keeping an open dialogue, keeping the communication going, making sure that that client knows the status of the matter, is given enough information to make informed decisions, that you're not hiding the ball, that you're not, straying away from those difficult conversations, and you're keeping them abreast of what's happening in their matter. The last one is the withdrawal, making sure that if it's not the right client, you've taken them on, you realize that continued representation may interfere with your ability to abide by the rules of professional conduct, may get you into malpractice trouble, going about the withdrawal or the termination properly and pursuant to the rules. So here we are at number 3. And this one is a biggie, and it's about dabbling. In this one, the law firm handled all kinds of IP related matters for its clients. And at one point, the client asked the law firm, "Hey, we need somebody to handle our corporate restructuring work." And what happened was the firm said, "Yeah, okay, we can do that as well." And they tried to convert the client from an S corp to a C corp. Ugh. But because they didn't know the law, they failed to send out the statutorily required notice of dissenter's rights to a minority shareholder. What happened? The minority shareholder sued, and the corporation had to pay a substantial settlement. What happened then? The client sued the law firm for legal malpractice, and the damages were the settlement that they had to pay that was actually driven higher by the delay that the firm had in doing the restructuring work to begin with. In this case, how was it resolved? Well, the suit wasn't filed, but a tolling agreement, pushing it out, was entered into. Defense counsel was retained, and the focus on this one really was the causation damages. The argument that the minority shareholder would have sued the corporation in any event because the corp was, trying not to pay. They were trying to get out of their financial obligations. They also focused on the successor counsel's conduct in this matter. There was a pre-suit mediation, and despite an opening demand of almost $2 million, the matter was actually settled with both firms paying in the low 6 figures. How do we talk about dabbling? Both from an IP practitioner's, going out into corporate restructuring, or that person who doesn't routinely practice in trademarks coming into the practice to represent someone, on a one-off. Certainly, I think that, there are inherent risks when a practitioner tries to practice outside of their own comfort zone. On a sporadic basis. It's not their area of expertise. It's not their specialty, particularly in an area in which they have little experience. Typically IP, it's very sophisticated. It's very specialized. It doesn't happen that often. But the old mantra comes into play, I know just enough to be dangerous. And that's where attorneys and practitioners get into trouble. Of course, attorneys have, free range and a broad right to practice in any fields of law. But as time goes by and their careers evolve, most lawyers, go to one separate specialized practice. I'm looking at here, there are over 1.3 million licensed attorney in the United States, according to the 2022 demographics from the American Bar Association. And while it is still possible, I'm talking about, kind of old school, for you to be a general counsel and handle everything and all things on behalf of one client, I'm not sure that that's the best practice in this day and age. Lawyers tend to dabble for a whole variety of reasons. It can be purely economic. It can be, you provide business services to a corporate client, and then they ask you to get their patent or their trademark. Some lawyers, by virtue of their brilliance, think that they can represent everyone all the time. But I'm just not sure that that's the case, and you really need to be particular. Some ways that you can mitigate the risk and how you can avoid dabbling in this regard. The first thing is, and I, as an adjunct of legal ethics and professional responsibility, and sort of a self-described legal ethics nerd, I am one that says, go back to the rules, right? Review the USPTO rules of professional conduct, particularly 11101, the competence rule that talks about possessing the legal knowledge, skill, thoroughness, and preparation required for the representation. Make sure that you understand it, that you can comply with it, and that you're acting within the bounds of your knowledge. The other thing is being candid, being upfront. Tell the client in what areas you are experienced. If their case falls outside of this zone, but you want to take it anyway, explain your plan to get up to speed. Maybe it's a case where you can do a little research, do a little due diligence, and get up to speed and have the kind of knowledge, the requisite knowledge to represent them. And then let the client decide whether or not they want to go forward. The other thing to do is you don't have to necessarily dismiss it out of hand or decline it out of hand. You can associate with co-counsel. Um, you can bring in another experienced practitioner or consultant to help you on the matter. A retired lawyer may be perfect, an attorney or a practitioner in another area of IP law. But the thing you need to remember is you've got to make sure that the client agrees to the arrangement, including how the case responsibilities are going to fall out between you and co-counsel. And you also need to get their consent to it in writing. I talked a little bit, and I think this is still a viable way, is the to educate yourself. If you've never handled it before and you don't know exactly what to do, it may be okay. It may be possible to do what it takes. Attending CLEs, acquiring a mentor, joining a bar association and going to meetings, to webinars, acquiring the necessary skills. Certainly with highly technical and specialized IP and trademark work, this might not be an option. The other thing to consider with regard to this is no client is going to want to pay for you getting up to speed. They want you to be the expert out of the door. So you're not going to be able to bill your client for the time. You're not going to be able to bill your client for the expense of doing so. This is something, being a lifelong learner and educating yourself as you go along. We talked about not accepting a case to accommodate or a friend or relative. That never seems to go well and leads to a lot of disciplinary as well as malpractice complaints. Don't let your inexperience in an area hurt your clients. While, of course, I said there were 1.3 million attorneys out there in the United States, but sometimes practice areas are very small. Opposing counsel will know your reputation, they'll know your background, they'll know your specialty. And in fact, they may even try to leverage your lack of experience in the setting or the practice area to push a resolution in the matter. It's one thing, to handle it and fail, but it's another thing to get involved in a very complicated, technical, specialized infringement matter and then have to deal with the other side who knows you're not prepared. Another thing to consider is just get out. You've accepted the client, you realize you can't handle it, just withdraw if necessary. You don't want to make matters worse. If you find yourself in over your head, just, withdraw from the representation properly under the rules and don't do anything to prejudice the clients. And of course, get office permission if required. And then the last one, which I think is the most hard, is just say no. Right at the outset. It's very hard to do, easier said than done. Don't make it personal. Just explain, I lack the time, experience, resources to handle this case. You'd be better off with another counsel. You can even make a referral if you don't want to leave that client hanging. The bottom line with dabbling is avoid a malpractice complaint, avoid a disciplinary complaint by sticking to what you know and what you're good at. So example 4, this is a litigation issue. And in this one, the firm was hired by a well-known European manufacturer to bring infringement claims against stores selling knockoff version of the manufacturer's goods. The law firm hired an investigator to go to one of the stores and purchase one of the knockoffs. In the suit against the store, the law firm drafted an affidavit for the investigator, which actually contained inaccuracies, things that weren't true. When the inaccuracies were brought to the judge's attention, the judge allowed the store to refile a motion for summary judgment and then delayed the trial for more than a year. The manufacturer then went ahead and retained successor counsel, who successfully tried the case to over a $1 million verdict. No surprise here, the manufacturer then sued the original law firm, claiming that their negligence increased the fees and a decreased verdict. How was this situation resolved? Well, luckily, the matter was reported during the underlying litigation, and defense counsel got in right away to assist. They assisted the law firm with giving information to the successor counsel and then continuing to monitor the matter. Tolling agreement was executed, a demand was made, there was a mediation that unfortunately was unsuccessful, but there were still ongoing negotiations throughout the mediation or through the mediator. Ultimately, what ended up happening was the matter settled for a low six-figure payment and a waiver by the law firm of some of the fees owed by the manufacturer. And you may be asking, how do we get around this? What are you talking about? How can we be proactive in this regard with the litigation error? And I'll start with the second one, and it's, candor toward the tribunal, candor toward the office, the Patent and Trademark Office, before the PTAB, the TTAB, before the Federal Circuit. Whatever the court is, whatever you're filing, whatever evidence you're bringing before it, must be truthful. There cannot be any misstatements of material fact. And we're looking at 11303A1 as well as 3. Being very careful, completing the due diligence, reviewing the documents to make sure that what you're filing is truthful. And if you realize that something has been submitted and that it's not accurate, correcting the submission with the court. The other thing I bring up here is pretexting. You may have heard of this concept where you're getting, you're someone to do something that you as the attorney might not be able to do. Typically, this happens in the social media sphere, where we see investigators or even lawyers sometimes impersonating another person to get access to discovery or evidence or information on the sly, where they're not revealing the true purpose or who they are, and they basically get someone to give them something that they wouldn't have if they knew who was asking. Be very careful, not only with 11401 when you're dealing with third parties and being honest and truthful, but also with regard to 11804A. And that says, you can't attempt to violate the rules, and you basically can't get anyone else on your behalf to do it for you. So example 5, this is another litigation error, and this is a legal fees type of error. In this one, the law firm was retained by a corporation to defend it in a trademark infringement litigation. Despite this going on for years, only 6 months of discovery was allowed by a judge. The adversary was granted a motion for summary judgment, and the judge precluded their damages expert. Why? Because they didn't timely file their disclosure. The original law firm was replaced as counsel, and after over a $3 million judgment was entered, the matter settled on appeal, lowering the amount down to $2.5 million. What happens? Oh, guess. They file suit for unpaid fees, and as expected, The counterclaim came alleging malpractice. How was this one resolved? Well, there were a whole bunch of complicating factors in this one. And unfortunately, in this case, we see the well being of practitioners come to a head in that the lawyer who litigated the defense had some mental health issues that precluded the lawyer from participating in the defense and in two potential jurisdictions. Defense counsel was ultimately retained. The focus here was again on the causation defenses. Luckily, an early mediation was held, and it resulted in a high six-figure settlement, in addition to waiver of the unpaid fees. What do I say about being proactive in this regard? I think there are a whole bunch of risk control measures that you can take to avoid these types of fee disputes. And the best one I can say is sticker shock. Avoiding the sticker shock by having conversations with your clients all throughout the representation, not just at the beginning, not just when you send them the final invoice, not just when you ask them for an additional money to replenish a retainer, but having conversations all throughout the representation. Also, setting expectations at the outset during the intake process. This is when we will issue bills. This is when we expect you to pay. These are the consequences if you don't pay. Additionally, and similarly to what we talked about with the client before, assessing the client's ability to pay. If they don't have the money, if they don't have the financial resources to fund this litigation all the way through, to fund this patent prosecution, this trademark process, there's going to be an issue and you may be out money. I think, you must get it in writing, because if it's not written down, it didn't happen. And then asking for a retainer and billing down from it is always advisable. In addition, efficiency through technology. There's nothing greater than so many different computerized platforms for your billing. Again, it's only as good as the information that is put in, but if you are careful, it minimizes errors, it facilitates efficiency in the billing process. You can see real time where there are problems with your accounts receivable, with your accounts payable, and it alerts attorneys way before there's a problem to emerging billing issues. The other thing to say is, good billing etiquette, right? Bills that clearly and accurately describe the work that's being performed. Monthly billing as opposed to at the end billing, so that clients can pay in smaller increments if that's necessary. Sending clients a status update with every bill sent, even if nothing's happening, even if you're waiting for something from the examiner, even if you're waiting for a ruling, just to let that client know, I'm working on this, I'm monitoring this. Nothing is worse than having a client come and say, you made a mistake on this invoice. You want to make sure that you're reviewing the bills for overcharges and errors before the client sees them and making revisions before they go out. Tiered billing process reviews, having other eyes look at the invoices, cutting clients a break if you can, making certain entries as non-billable time, zero charge to the client. And as I said, having this discussion be ongoing. Overdue bills, reach out to the clients. Determine why they're not paying. It could be you've got the wrong email. It could be you have the wrong mailing address. Whatever it is, there may be a legitimate reason other than I just don't want to pay you or I don't have the money. Figure out what it is beforehand. Direct communication with that client is always more effective than a form letter with a big red stamp saying, overdue bill from your accounting department. Additionally, like I said, consider what the issue is. What's the reason for the non-payment? And if there is a reason, consider a compromise. You don't want to go straight to the collection action and the subsequent, claim, malpractice claim. See if you can reduce the fees. Maybe even if it's an ongoing client, one that you represent on an ongoing basis, see if you can give them a credit to future legal fees. Client avoidance, you got to make a decision. Are you going to file something? What are you going to do? Are you going to write it off? Are you going to terminate from the representation? You also want to consider what my likelihood of success is versus how much time, blood, sweat, and tears am I going to take put in to this collection action. And also remember, the client bankruptcy. If they're judgment proof, you're not going to get anything. Some other adverse consequences to be mindful of, disciplinary grievance, damage to the firm's reputation. You may have to disgorge fees that were already paid, and excess costs that aren't covered by that aren't included by your coverage. 50,
So
almost. Oh, go ahead, Bree. Hi.
no, I was gonna say, I saw you switch slides. I
Yeah.
didn't want to interrupt you, but I do want to say the code. So everybody get out your pencil and your paper to write down the code. The code is the number 4, the word claims, the number 5. That is 4 claims. 5. I hope you don't see any ever. All right.
Right?
Carry on.
Exactly.
That's the only claims I ever want you to see.
Yes, exactly. Going through some of these steps, and when you get to the last step, my question, if you go through all of these steps and you look at the legitimacy and your bills are reasonable, under 11105, you want to go forward with it. And the adjusted balance is still high enough for you to file a collection action. You're going to meet with the collection attorney, but I also think this is a good time for you to reevaluate your billing and collection procedures. This is something that should have been done proactively so that you hopefully, fingers crossed, didn't get to this point. Issue 6, a conflict issue, which is, quite frankly, and for years going, is the biggest area of legal malpractice complaints, not just in IP, but across the board. Case here, it will look very familiar because it's out there when we think about IP representation. This is the kind of thing that happens. Law firm is known for representing one business in everything. They do all their IP work, and of course, in doing so, they represent companies that are competing with one another. And one of their clients, the company, asks the law firm to file a provisional application for advice if one of their competitors' products infringed with theirs. And the law firm said, yeah, no, it doesn't. Yikes. Ugh. Direct adversity. It turns out that the competitor was also a client of the law firm, bad conflicts checking system. And that competitor actually asked the law firm to send a cease and desist letter to the company, and they did so. Then, the company said that they're going to pursue a claim against them. In this resolution, get rid of this quickly. There is clear liability here. The claim professional, immediately identified that there's not going to be any defense here. There's no defenses to duty, breach of duty. The claim professional, solicited a demand, which was $25,000. Quick and direct negotiations, so the matter was settled. They were able to resolve the issue without retaining defense counsel, which would make the costs go up. And luckily, the firm, was able to get past it and get back to the business at hand very quickly. Why do we care about conflicts? Well, a number of reasons. One, we're fiduciaries. We have a fiduciary status. We have to be concerned with the loyalty and the confidentiality. All kinds of ethics and disciplinary grievances, malpractice issues, disqualification from cases, fee disgorgement, your business reputation. When you see those things on Law 360 or ALM, whatever it is, the cases around disqualification in IP matters, your business reputation, the trust of the client, They may, say, look, if conflicts of interest are all about loyalty and confidentiality and you've broken that trust, I guarantee that client's going to walk away. Clients expect this loyalty. You're supposed to put their interests first and not have actions against their interests. They also expect confidentiality. They come to you for a reason. They tell you things that are private and confidential and are meant to stay that way. It's this sort of bond, if you will, is essential to the relationship. It encourages clients to be candid because they couldn't be if you weren't going to hold their confidences. And it's really, a key issue towards the conflicts of interest, particularly with direct adversity. And that's the rule that's up on your screen now, the 11107A. Looking at that concurrent conflict of interest, this direct adversity or this material limitation. Either the representation of one client is materially limited by your own interests, by your interests owed to a third party, or to your interests owed to another client, as we saw in the claim situation that I just talked about. Also, you have to consider the direct adversity, the butting heads, representing clients on opposite sides of the V, or going against a client's interest, or even particularly important in the IP sphere, subject matter conflicts. Of course, with conflicts, there are always exceptions. The biggest one, and I think the biggest hurdle here with the conflicts, is subsection 1, right? Practitioners seem to always reasonably believe that they will be able to provide competent and diligent representation to each affected client. Rarely is that true. The other problem here is the subsection 4. Each client giving informed consent confirmed in writing. Sometimes I think if you actually told the client everything that was required for an informed consent, all the risks, all the liabilities, all the other options, how many of those would actually sign it? They do. And depending on the sophistication, of course they do. And they would have to, otherwise we'd only have one client. But it's something to be mindful of. It's something to be particularly mindful of with your conflicts checking system, making sure that you have great, I should say, detail in that conflict situation and control. A couple more before our time runs out. Issue number 7. This is one of filing issue. This is where a law firm was retained by a company to represent it in the purchase of a whole bunch of patents from another company. And as part of the purchase, an agreement was signed which included an assignment of patents. And to reflect the change of ownership, a lawyer at the law firm instructed his assistant, to file the signed agreement and the assignment on the PTO's electronic filing system. Problem was that the agreement and the assignment contained all kinds of confidential and proprietary information, which was now visible by the general public, right? It was out there. It was out on the website, or I should say out on the system. So what ended up happening, the company advanced a claim against the law firm alleging malpractice and damages of over $30 million. Those damages included fees to remove the document from the USPTO system, the loss of a deal to purchase another patent bundle because of what they had done or what they had published, as well as the loss of the ability to sue certain entities for patent infringement. So you're wondering how this the ethics rules requiring attorneys to electronically file their own documents. The insurance carrier retained 2 experts to look into the damages. They looked at the engagement letter, which provided for arbitration and pre-filing mediation. They had direct negotiations um, concluded, conducted by the claim professional. And finally, and luckily, a settlement was reached, which was a significant payment paid out, right? As well as an agreement to pay counsel fees up to a certain point for their work in trying to get all that confidential data removed from the PTO system. Also, in indemnification if they should file suit. And so, here, what am I talking about? What am I talking about being proactive in this regard? Well, I think you've got to talk about supervision, right? 11503, supervision of non lawyer assistants, not only paralegals. But everybody who comes into your sphere that is doing work for you. And that could be contract attorneys. That could be IT outsourcing, investigators, making sure that you, as the practitioner in the firm, the supervisor, have reasonable assurances that all of those people, all of those non lawyer assistants, understand what the rules of professional conduct are under the PTO, and making sure that it's that they're following and abiding by their responsibilities. The other thing to remember is electronic. Oh, I see my video is frozen. I'm sorry about that. I'm hoping that you can still hear my voice. The other thing is about electronic signatures. We look to the rules of the PTO on that issue, and we look to what they're supposed to do. Uh-oh. I'm sorry that my video and my audio is having trouble. Um, you want to make sure that you are complying with the appropriate procedures before the office. And the proper method is the S signature. I'm going to show you some of those examples, the examples of proper typed electronic signatures, which you can see on the screen in front of you, as well as some improper typed electronic signatures. Making sure that, like, I'll go back, making sure that you actually abide by 37 CFR 1.4D2, making sure that it is with the forward slashes, and making sure that, if you're, going forward, here you are, proper electronic signatures using a stylus. I also want to talk about some of the hidden dangers with regards to not only non-lawyer assistants, but the USPTO has in the recent past seen a rash of, I'm going to call it, renting your license, right? Renting your name to someone else. You're sort of the conduit for a foreign agent to get those trademarks filed, to get those patents filed. And the first case that I have on the screen is the Lee case. And in that case, it was a Southern California-based practitioner. The ultimate sanction was a reprimand and probation. But what ended up happening was the U.S. practitioner, was allowing a Chinese company called Seller Growth to file all kinds of trademark applications on her behalf. She also allowed this Seller Growth to place her signature on trademark filings over 1,000 times. Again, the signature that we've been talking about, this due diligence, this vetting. The David case is another one, and it's a prime example of sort of renting out your name or renting out your license. This is one that came down in 2021. And David was a practitioner based in Massachusetts, and he was also reprimanded and placed on probation for a 12-month period. And in this case, what happened was David was, put himself out there on Fiverr. It's the platform, for connecting attorneys and others with clients, right? Referral services, and put himself out there and met Wen. And what ended up happening was the deal was that David was going to receive $30 per trademark application, and allowed Wen and Wen's associates to actually file them with the PTO, all under David's name and all without David's review or approval of any of it. Like I said, he was just the conduit, he was just the name, he was just the license that got these trademark applications filed. In fact, David didn't personally sign at least 45 of the filings. And the thing that I thought was particularly interesting about this case was, it wasn't Wen or David that called out the conduct. It was actually the PTO who reached out to David and said, we think somebody's impersonating you. We think somebody is using your name and your signature improperly to file these applications. Unfortunately, what ended up happening after this was brought to light was that David wasn't truthful. He made a false or misleading statement and filed a false declaration before the PTO, claiming, I didn't authorize these filings, when in fact he authorized all of them. So it was a big problem and a big he actually had to take some CLEs too, some CLEs in ethics, as well as some CLEs in trademark process and trademark law. The Reddy case, similar, another reprimand on consent. She was working, she actually, in this case, unlike David, she actually signed I think it was over 2,300 filings, trademark filings with the PTO, but did nothing else, right? It was just the signature. No due diligence, no review, no communication with the client. Didn't make sure that everything was proper, was truthful before the filing. And then the last case that I like to talk about is the Liu case. In this case, again, a 2021 case, the Beijing-based attorney was suspended for 3 months and placed on probation pursuant to consent. He agreed to the discipline for his relationship with IP company. And in the final order issued by the PTO, Liu had a tiered fee schedule, and generally was paid actually less than David, was paid about $20 per trademark application. And over the course of the relationship, however, because the volume was so great, he was paid up to about $10,000 per month for 500 applications per month. And some of the words, and I excerpt it here for the slide because I think it was particularly important. The final order stated that Mr. Liu knowingly and intentionally caused thousands of trademark application documents to be prepared, signed, and filed with the PTO on behalf of this applicant, and knowingly and intentionally became the attorney of record for it. So incredibly problematic, not paying attention to due diligence. And we see a lot of cases where U.S. attorneys are not communicating properly or allowing foreign agents to pass work through, or for the U.S. attorney to be the conduit in that regard. I'm going to give you my contact information, and I see a couple questions, and I've got about 2 minutes to answer some of them, which I will do. And one of them is, have I ever seen a malpractice claim based upon information given online on a website for selling templates? Interesting. And again, I'm not in the claims department, although I work closely with underwriting as well as claims at CNA. And to date, I can say I haven't seen those types of claims, but I know they exist, and I know they're out there. And the other thing that I will say is part of the problem here, and when we talk about online information, connecting with potential clients online, we talk about solicitation, we talk about advertising, and we have to talk about, and we don't have time to do it here, about how practitioner-client relationships are established and what kinds of communication lead to the establishment of that relationship and to the client saying, hey, I thought you were my attorney. I thought you were working on my behalf. I know maybe we didn't sign an attorney client retainer agreement, but when you look to the restatements, excuse me, it's the client's belief, the client's reasonable belief, but it's the client's belief that dictates in that regard. Um, let's see. I think,
Okay.
unfortunately, our time is up for this afternoon. I do know that we're having a post webinar discussion, and hopefully, we can come up with some answers to some of these other questions. If you have a question that I didn't get to, or that we're not going to be able to get to in the post discussion, please feel free to reach out to me. Happy to talk. Happy to set up a time to talk. And I
Hey,
think, Bree, I will turn it back over to you.
perfect.
Let me know if that's correct.
Yes, absolutely. So we will have the post-session discussion here in about 5 minutes. Why don't we all take a quick bio break, go get a drink of water, and then I will see everybody, I hope, in the post-session discussion where Tracy will take some of these questions because there were a lot and they were good. The chat was obviously on fire this entire time as people were sharing their own experiences and their own, oh no, not that sort of reactions. So definitely um, come join us for that, but do take a very quick break. Um, Thank you so very much for this. I think we all learned a ton. I think it was actually an entertaining ethics, Yali. So thank you for that. We really appreciate it. It's not easy to do. So thank you. Everybody take 5, and I will see you in the post-session discussion at 5:35 Eastern time. All right. Thanks again, Tracy.